19, and I think she's in her early 50s. And then the third name, as you alluded to, is Allison Rushing. She's appointed to the U.S. Court of Appeals for the Fourth Circuit, which includes the Virginias, Maryland, and the Carolinas. And she's only 38 years old. It's been a very, very long time since someone that young was appointed to the Supreme Court, back when you'd have to go back to the time when life expectancy was about 45 to find someone who was that young. But she, too, she clerked for David Sentel on the D.C. Circuit, clerked for Justice Thomas on the Supreme Court, and is well known for, and she does do a fair amount of speaking on the Federalist Society Circuit. And President Trump has kind of an abundance of riches, if you will. He's got a deep bench, unintended, I suppose, to choose from. He's appointed many. Almost all of the women who are on his broader list, he has appointed to the U.S. Court of Appeals, and many of them have in turn clerked or kind of been mentored by some of the real legends of the conservative legal movement, and this is one aspect, I think, of why it's so important that presidents choose wisely when they're appointing justices, because a justice, take Scalia or Justice Thomas, for example, it's not just the opinions they write or the votes they cast in the cases that come along. Justice Thomas has over 100 former law clerks who are, by now they're partners in big law firms. They've served in very high positions in the executive branch, and now I think 7 or 8 of them have been appointed to the federal bench across the country. That's a huge impact on the judiciary, the law, the country, that goes way beyond what an individual judge's service is. So I think those are the 3 leading candidates. Judge Barrett was, I think, widely seen as sort of the runner-up in 2018 when Justice Brett Kavanaugh was appointed. She had a pretty high profile then as well, and now has 2 more years of opinions and judicial service under her belt. And I'm not a betting man, but if I were, I would say that it's probably going to be her. She has the right profile for the kind of justice that the court needs, that this administration, it's very consistent with the way this administration has approached appointing judges. And I think I look forward to watching a hearing we don't really know how a hearing like this will be conducted under these circumstances. It is a pandemic still in full force, after all, and the Judiciary Committee and other committees in the Congress have held hearings, but they've been radically, changed in terms of sort of the dynamic in the room. And as everybody knows, that dynamic when it comes to a hotly contested Supreme Court nomination can be very dramatic. Well, it could very well be that old COVID-19 will have the effect of dialing that down somewhat, which I think wouldn't be a bad thing. But I think Judge Barrett will do very well in a hearing about these issues.
Sure, Tom, let me go back to her initial confirmation when she went to join the Court of Appeals. There was some controversy, a couple things. One, there was some controversy of the questioning that was done of her by Senator Feinstein, particularly on
Right.
sort of criticism of the sort of religious tests. She was questioned about her Catholic faith, and Feinstein suggested that somehow that was inappropriate, and there was some pushback there. But then I would just kind of follow on. That nomination was very much a divided Senate. There were only a handful. I think there were only 3 Democrats who voted for her. She was confirmed 55-43. 2 of the Democrats who are still in office are Tim Kaine and Joe Manchin. So was that an issue when she was passed over last time, as you mentioned? And how do you think that would shake out in this? And obviously, somebody like you who've been worked in the Senate knows that whole process.
Well, I think the first thing, and I hope Republicans look at this issue in this way and approach it in a way that could be constructive. People need to understand why, in these hearings, for example, Democratic senators focus so strongly on what a nominee's personal beliefs are. She's not the only one that's been asked about that. There have been a couple of other, even district court nominees who were, let's say, members of the Knights of Columbus, or one was an evangelical Christian, and one of the Democratic senators almost told him that alone was disqualifying. Well, it's not necessarily that they're just religious bigots. The question you have to ask yourself, why would someone's personal views on various issues matter so much in a judicial nomination? I mean, they're not running for Congress. They're up to be a judge. And the answer is that the left and Democrats in the Senate have a very political view of the judiciary. They believe that judges decide cases based on their personal views. And so, since that's the basis on which they think judges can and do decide cases, what someone's personal views are is everything. That's why they explore that so much. That's why if someone like Amy Barrett, who's not just Catholic, labels are kind of funny. I'm a Presbyterian, so we don't have that problem. But she's a Orthodox Catholic, or she's a conservative Catholic, or whatever. After all, they say Joe Biden is a Catholic, and the media loves his Catholicism, but it certainly doesn't like Amy Barrett's Catholicism. But the reason that was so troubling to Dianne Feinstein, for example, is because if you believe that someone uses their personal views, including their personal religious beliefs, to decide cases, and if someone is a committed Catholic and an abortion case comes before her, there you go. I mean, supposedly that will tell you how she's going to rule. But that's the reason why there's these really intrusive kinds of questions about personal views. Another Trump nominee, Naomi Rao, who was appointed to the U.S. Court of Appeals here in Washington, one of the Democratic senators asked her if she thought homosexuality was a sin. Now, that is, I've been attending confirmation hearings for 30 years, and that has got to be one of the strangest questions that I've ever heard asked. And so you have to ask yourself, why did that senator want to know that of a judicial nominee? Well, that's the reason. So I really hope that there's an effort to expose that, to really not just to immediately get sucked into a hair-splitting discussion about what somebody's religious views are, or to try to say that you should never ask about religious views. You can ask about anything you want if you're a senator, but people need to understand where that's coming from, and they need to understand what that says about that senator's view of the judiciary, because that's always the issue, is which kind of judiciary does America really need? One where judges decide cases based on their personal views, or one they decide cases based on the law. So when Senator Feinstein said, the line she used was, "The dogma lives loudly in you." There, too, is one of the strangest things I've ever heard in a confirmation hearing. But that's why she was so concerned about that. That's why when she could hear from Amy Barrett that her Catholicism and her beliefs were deep and her conviction was strong, that's why it made Dianne Feinstein nervous.
Jackie? Don?
No, I mean, you asked the question I was going to ask Mark, which was about his take on the religious. Okay, so Don, what do you have?
Yeah, Tom, I'm just kind of wondering about on these nominees and everything like this, that with Lagoa, particularly with not much of a track record. I mean, there are some advantages, I guess, because, you know, she's the daughter of Cuban immigrants and whatnot. I mean, I don't know if there's a political angle for her on this over Barrett, or you know, as you say, I mean, I think Barrett is the leading candidate, but you know, would there be a lot of objection in Republican conservative circles to Lagoa?
Well, if you look at you know, nominations, particularly Supreme Court nominations, going back maybe 30 years or so, there's a great deal of difference in the care with which different nominees were chosen. Of course, David Souter comes to mind as who was nominated by the first President Bush in 1990. He'd only been a federal judge for a few months, and before that was on the New Hampshire Supreme Court. But the main reason he got chosen was that he was close to John Sununu, who was Bush's chief of staff and who had been the governor that appointed him to the state Supreme Court. Well, okay, that's not likely to be a good indicator of the kind of justice that someone's going to be. And sure enough, Souter ended up being the wrong kind of justice. And then the next year, Bush appointed Thomas after having taken the care that the president should take, and then we got exactly what we should have. So all of that is to say, by this time, the Republican constituency certainly is more attuned to what it is that we need in a Supreme Court justice and how we get it. And the sort of surface level considerations of, well, she's Cuban and that kind of stuff doesn't fly anymore. 25, 30 years ago, it might have mattered a little bit, but having been disappointed or surprised in the wrong way too often, and having those disappointments caused by a lack of focus on the right issue, and race is not a qualification to be a judge. I don't think that really works anymore. And so I think, obviously, I'm not advising the president, but I have a sense of those who are, of kind of where they're coming from. And I think they would probably put more of the appropriate emphasis on just the kind of justice that someone's going to be. If you can find someone with that judicial philosophy and commitment who also happens to be female, a racial minority or something like that, maybe all the better. I don't know. But I think you're right that the fact that she's I wouldn't say unknown quantity, but lesser known, and obviously the stakes are highest with the Supreme Court, probably doesn't move her up in the standing, so to speak.
It is interesting that you say that, though, because I feel like if we were looking at this, if there was a Democrat in office, I feel like it would have, just going back to as far as seeing Joe Biden saying, well, of course I need to pick a black female, and that those labels do seem to matter when it comes to the left as opposed to the right. Not saying that you're incorrect in that. I don't think that the Republican Party cares as much about having those labels there. I actually think it was a smart choice on to Trump's point, to pick a female to replace somebody as influential in women's rights as Ruth Bader Ginsburg. But I think it's an interesting way to see it from both angles, and then I think that the Democrats would have cared more about picking a Latino woman as opposed to any woman or any person who would qualify for the job. And then I wanted to ask a little bit more about timeline, with getting done.
I think there's something to that, and again, I think it's consistent with what I was observing before, which is, if you ask yourself, why is it that they would consider race and sex to be so significant in terms of literally a qualification to serve on the Supreme Court, you get the sense that, well, because they believe that race and sex affect how people think and how they look at the world. And since judges decide cases based on how they think and how they look at the world, right? I mean, so it's all kind of bound up in this very political, ideological view of the judiciary and how judges go about deciding cases. I do think Republicans probably could have, and I think they should, have an eye toward. One of my former bosses didn't like the word diversity, so we always use the word variety, which has a little bit less baggage to it. And I do think that Republican presidents, if their first priority is a commitment to the right judicial philosophy, if they can also appoint as many or as varied a group of judges in terms of these kinds of demographic factors, the better. I do think it's very good for the country to see that a traditional judicial philosophy is not just for white male judges, that these are fundamental principles that have to do with our liberty and are shared by everybody. So we ought to have a judiciary where women, minorities, white males, all are representing and applying these same fundamental principles. So I do think there's a place for that, but it's a second and third consideration, not the first one.
Going back, we talked about the appointments that first President Bush made, and I think one of the reasons for Souter, as I recall, was that concern, I think I have the chronology right, that Bork had too much writing, and therefore because of his work as a scholar, had provided a lot of fodder. Now, we could talk about that nomination. We could do a whole show just on that, because it really was a pivotal moment in the whole confirmation process. Coming forward, one of the issues is as you mentioned, Judge Barrett has written quite a bit on stare decisis and the whole concept of precedent. Tell us, will that be an issue if she is chosen that would create some vulnerabilities in terms of how it gets portrayed?
Well, I think your take on the Souter nomination is basically right. I had my own conversations with John Sununu at that time about that nomination, and he explained that the Bush administration strategy was for the first appointment that they would have, and that turned out to be the Souter nomination, but they wanted to have someone who would be overwhelmingly approved by the Senate, as little controversy as possible, and then if they had another one, that would be a much more kind of red meat, true principles, fall on your sword, sort of thing. And that is how it turned out with Justice Thomas. Whether that was I didn't think that was a very smart strategy at the time. I thought it should go the opposite way. Frankly, you lead with your strongest candidate, but that's why he was chosen, and his record was almost purely judicial, and they figured that would contribute. And he was confirmed, I think, 90-9 or so. So they did get what they wanted, but of course, we ended up with something that we didn't want in terms of his service on the Supreme Court. Again, we've come a long way since then in terms of the debate over judicial philosophy and originalism, and there's more and more prominent professors and now appointed judges who have a commitment to that approach to judging, and who have expressed that in their cases and their writings and so on. So it's less risky in a sense to have a paper trail of that kind, so to speak. My personal view is, frankly, especially if you're going to replace the leading liberal on the Supreme Court, go for the gusto. I mean, that is the issue. It always is what kind of justice is this person going to be? When a justice looks at our written Constitution, do they see anything more than what's written there, or do they make stuff up? I mean, that's That's always been the core issue, and our country needs justices who are committed to that traditional judicial philosophy. And frankly, it's better that we have someone whose record clearly shows that they've long understood and been committed to it, have a rigorous debate about it, both in the hearing and on the Senate floor. And I think the country can benefit from that, even if someone would be defeated. I don't think if Amy Barrett is nominated that she will be defeated, but you can still make a tremendous contribution to our fellow citizens understanding our system of government, the way it's designed, and you haven't wasted the opportunity. I think trying to have a stealth nominee who is, kind of flies under the radar and no one's really sure about the costs far outweigh the benefits of that kind of appointment.
Go ahead, Jackie.
I was going to say, one of the other really fascinating things about this appointment, as compared to what we saw in the Obama administration, was that, there's that whole rhetoric of, well, when Obama tried to do it in an election year, within a year of the election, the Republicans said, oh, no, you can't do that, and now all of a sudden they're flipping the script, and obviously there's a lot of bias being put on both sides. So can you kind of break down the timing of it a little bit and what your take on that is?
Well, and I was Senator Hatch's chief counsel on the Judiciary Committee in 2016 when Justice Scalia passed away. And so, we were part of all of the discussions about what kind of approach we should take, what sort of strategy should we follow. Justice Scalia died on February 16th, 2016, and it was 1 week later, so the 23rd, the Republicans on the Judiciary Committee, and Republicans were the majority at the time, they signed a letter to Leader McConnell saying that they would not hold a hearing until after the next president was inaugurated. Now, two things are important to that. One is Obama hadn't made a nomination yet, so this wasn't just a matter of, this is just kind of a sneaky way of trying to defeat a nomination they didn't like. And second, everybody thought Hillary Clinton was going to get elected at that point. So it's not there, it's not that, we've got to keep this open because we think, Trump will get elected. It was genuinely, I think, if it had been done 6 weeks before the election, it'd be different, but it was done almost 9 months before the election. So they took that position, and they did it for two reasons. Number one, and they put this in the letter that they sent to McConnell. They said it was divided government. You had a a Democratic president and a Republican Senate, and the election that year was certain to give us a new president. This is Obama's last year in office, and he wasn't running again. So both of those factors were significant in Republicans saying the best way to handle this nomination at this time is to defer it until after the next president takes office. You can disagree with that. People might say, well, I don't think those are significant considerations, or I'm not persuaded that should have changed anything. And certainly Democrats took the position at the time that circumstances don't matter, that the Senate should always consider a president's nominations, even in an election year. But Republicans took the position that circumstances do matter, and that both of those circumstances taken together led to their decision to defer the confirmation process. Now, fast forward 4 years to this year, and the similarity with 2016 is on the surface, and that is it's a presidential election year, and you have a vacancy created by a justice's death. But that's all the similarity that there is. With regard to the two substantive criteria, the two reasons why Republicans did not take up the Garland nomination in 2016, neither one of them exists today. We do not have divided government. We have the same party controlling both parts of the appointment process. And for all we know, the incumbent president will continue in office after this election because this is his first term. So I think, common sense says that it doesn't that you shouldn't expect to handle different situations in exactly the same way. The only way that Democrats can make that criticism now is to pretend, I guess, hoping that people will either not remember or not find out that 4 years ago was the same situation as it is today. Because then you'd expect, well, you can't change positions in identical circumstances. But they're not identical circumstances. It's a different situation. Over the last couple of centuries, almost all, when we're talking about Supreme Court vacancies in a presidential election year, 17 out of 19 times, when the same party controlled the White House and the Senate, the president made a nomination and the Senate confirmed them, 17 out of 19 times. When different parties controlled the White House and the Senate, only 2 out of 9 times did the president make a nomination and the Senate confirmed them. So if those historical situations, and we can call them precedents, but they really aren't, they're just incidents, really. But if those historical situations are relevant, just do the math. The vast majority of times that this occurred under these political circumstances, the justice was appointed, and the vast majority of times when it was done under the circumstances that existed in 2016, the justice was not appointed. And so the pattern between these two, I know that Democrats want people to think badly about what Republicans do, but they're not telling the truth by trying to get people to believe that these two circumstances were the same. I think in both cases, it's a legitimate, defensible position, either deferring the process in 2016 or implementing the process this year.
Now, I think you've done some math in the past about how quickly some nominations have been completed, I was kind of struck by them. I was amazed by how Earl Warren went through, but that's a whole other issue.
Sure. To be fair, I've got to say the confirmation process has changed a lot.
Right.
During our history. It's become far more complex. But I think a lot of people assume that what they saw, for example, 2 years ago with Kavanaugh or whatever, that's the normal way it's always been done. And that just isn't true. I mean, the first Judiciary Committee hearing on a Supreme Court nominee did not occur until 1916. And even after that, more than a dozen Supreme Court nominees were confirmed, most of them very easily, without any hearing at all. So the practice of the Judiciary Committee holding a full hearing where the nominee attended and answered questions, the thing that we see today, that's only been the practice really since the late 1950s. And in fact, JFK's nomination of Byron White, for example, in 1962, he was confirmed 8 days after he was nominated. And I think his hearing lasted less than an hour. Going back a little bit further, FDR, Franklin Roosevelt, his nomination of James Burns in 1941, Burns was confirmed, I think, 4 hours after he was nominated. I mean, literally within a half a day. And he, of course, didn't have a hearing, had no opposition. Ruth Bader Ginsburg herself in 1993, her process took 6 weeks, 42 days. The process has lengthened by the addition of some steps in the process that didn't exist before. Everything from, FBI background checks to extensive Judiciary Committee questionnaires and all sorts of things like that. But if the Senate wants to do it efficiently, they have, every ability to do so. The Constitution does not specify how the process should be conducted. Even Senate rules don't contain any. There are far more Senate rules about the impeachment process than there are about the confirmation process. I mean, literally, it's the Senate can choose for itself even whether it wants to have a hearing, whether it wants to immediately vote on somebody. That has become the standard practice, but it can be done efficiently. And remember, the judges that we've been talking about, all three of these women, they were appointed to the U.S. Court of Appeals only in the last few years. So they were before the Senate Judiciary Committee with all of their record prior to being a judge, being examined really not that long ago. So it can be done. It can be done efficiently, and I think it will be.
Well, Tom, we're coming up on the end of the show here, so we wanted to first thank you so much for coming on the show. I mean, you are like an encyclopedia of knowledge, it seems, about the Supreme Court. Is there, if any of the people watching want to get a hold of you or have more questions for you, where can they go to find you or read more about what you do?
Well, if you go to heritage.org, that's where, everything that the Heritage Foundation does, you can search for my name, and each one of our staff pages, has a list of the things we've written and published. I think that the Heritage Foundation website will probably, if it doesn't already, have a specific section related to this nomination, and watch for not only myself, a couple of my colleagues. I should have a piece up on Fox News this week. I had a piece up on the Federalist today. We'll all be writing quite regularly on the various issues that come up in the course of the nomination. So heritage.org. You can also check out our judicial appointment tracker. That's heritage.org/judicial tracker, and that tracks for the entire judiciary what President Trump is doing and compares that to the 5 previous presidents. You can get a picture of the whole judicial appointment process.
Awesome. All right. Well, thank you, Tom, again for being on the show. Thank you, Mark, and surprise host Don for joining me tonight. And we will see you all next week.
Thanks a lot.